Yes.
Your Lordship, 13.6, this letter is regarding Miss So-and-so, daughter of so-and-so and so-and-so, referred by this Honorable for conducting sessions. Second para, Your Lordship. Based on the evaluations, the child appears to have misinterpreted about abuse, and it is clear that it has not happened. The child has constantly expressed negative views towards the father and unexplained high reluctance to interact with him over the last 1 year, and her responses in the therapy are possible reflections of her not talking to her father for the last few years. The child has been experiencing emotional/psychological symptoms in the background history of a high degree of marital discord between her parents. At the outpatient based assessment has been going on for the past 1 year, and not much progress can be made to improve the father and child interactions, and the inpatient evaluation has not been carried out. The findings should be viewed from the lens of this limitation. Regarding visitation, we have tried to prepare the parents to reach a consensus and prepare the child, but the child appears reluctant to talk to the father. Given these observations, we are planning to refer to the Family Psychiatry Center for facilitation of continued on outpatient basis. Last para, Your Lordship. Given the challenges faced in the outpatient based evaluation, and there has been no chance to observe the child in the absence of the mother, with the father, detailed inpatient clinical evaluation is needed for the following reasons. One, evaluation, detailed evaluation, family history clarification, serial mental status examination, serial ward observations, facilitation and observation of child and parental interaction, management, individual therapy and family therapy. To evaluate the possibility of parental alienation, Your Lordship, this has still not been done. Our objective is to offer neutral evidence-based input in full compliance with the Honorable High Court's directive. This recommendation is made solely in the interest of safeguarding the child's long-term psychological well-being and interests. Your Lordship may kindly recollect there was an earlier order which Your Lordship had referred to, wherein NIMHANS had also specifically stated Your Lordship's order was on 10/7/2024, 1 year ago, where NIMHANS has specifically stated that 3 weeks evaluation with the father, 3 weeks evaluation with the mother. Even that so far has not been conducted. Your Lordship, one of Your Lordship's similar such order, which Your Lordship had passed, went on to the Honorable Supreme Court, and the Honorable Supreme Court in that matter. In that matter also, Your Lordships, specifically they had stated that it appears to us that mother had obstinately deprived the father of the company of their minor child, overreaching orders issued by the Honorable High Court of Karnataka, and all this, the rest of it is so very similar, Your Lordship, and in fact they've appreciated this Honorable Court's the entire objective. Your Lordship, the NIMHANS has very clearly stated that none of the allegations are
In
true.
fact, in that order, I have referred about this case.
No, I'm aware of that order also.
No,
I'm
when
aware.
passing that order, I have made a reference to this case, saying that particularly in this case, I spoke to the director NIMHANS whether the evaluation of the child is possible on an outpatient basis. He said it is not possible. Then mother has raised all that what so called, and then we tried to understand whether something could be done. Now, from the report of the NIMHANS,
Now,
that nothing can be done.
No. May I refer to the NIMHANS report?
Yes.
Yes. My lords may just see.
No, before you're referring to the NIMHANS report,
yes,
please tell the court what is the date of the order of this court?
This
Earlier, just for your
10/7/2024.
So from 10/7/2024, nearly after 1 year, what is the difference?
No, I want to refer to my lord's orders. Kindly see my lord's 4/2/25. From the last order of 24, my lords had in fact passed orders that Saturday, Sunday to meet 2 hours, supervised visitation. My lords are aware of that. Then my lords may just see order dated 4/2/25. Just if I may refer. We were reporting how that visitation was going on, where the mother was taking her with a third party to the father's house. Girl was walking out. Kindly may I just take to para 5 of that 4th February order. Para 5. It is stated It is stated that some days session went on well and thereafter the girl was reluctant to look at the father, and even before visitation is completed, she herself was going out from the house of the father within 40-45 minutes. It is submitted that due to various reasons and at the behest and on being carried away with that is the allegation from the father's side, girl is not interacting with the father, and unless and until orders are passed, it would be very difficult. 6. Learned senior counsel appearing for respondent mother submits that mother is making her best efforts to see that girl develops bonding with the father, but so many times she's showing reluctance to even get out of the car. She's hiding under the seat and she's reluctant to go and meet the father, and she stated that she's undergoing counseling with some other with another doctor so and so. Now kindly see at para 10, my lords.
Yes.
On the last occasion, it was brought to the notice of the court that father is touching her and she's not comfortable, and then this court made it clear that when the girl is not comfortable, the father should not indulge in any of those activities. The fact remains, this my lords had recorded, the child is, for whatever reason, her behavior is not normal, and both mother and father should accept that she has some psychological issues which has to be addressed. According to doctors at NIMHANS, unless and until she is admitted as inpatient, assessment cannot be done. Mother wants her to have regular therapy, but not as inpatient. This court is conscious of the fact that earlier NIMHANS doctors had said that unless and until she's admitted as inpatient, they cannot assess her. However, considering the fact and circumstances and facilities that are available at NIMHANS right at this point of time, this court is not inclined to pass an order directing the daughter to be admitted to NIMHANS as inpatient. But at the same time, the manner in which counseling sessions are going on, there is not much difference. Till now, report of counselor is not placed, and whatever is placed, they do not contain any details about the treatment. Considering the NIMHANS is a thing, it deems it to pass appropriate orders, and the order to send the child to NIMHANS were passed. The reason my lords in fact thought it appropriate to send her to NIMHANS was because she was walking out of the visitation. The 2 hours visitation, in 30-40 minutes, she herself was walking out, and my lords recollect even the videos were shown. Thereafter, now my lords, the cover letter my friend has read out of the NIMHANS report. NIMHANS has, in fact, may I just refer every session, if I can please request my lords to see the same report. Every session they have recorded how the incidents took place, the session took place. I'll just point out some highlights. Page 2, my lords, at the bottom, the pages are there, page 2 of 12, etc. Kindly may I request page 2 of 12. This is the para starts session 2 on 15/2/25. May I read about 10th or 11th line of that para? She reported that, my lords found that line, she reported that she did not like meeting her father. When asked if she always felt like that or this was something new, she reported that it was always so, and she said she had bad memories of the day she was born. She could not elaborate or give reasons about the same, and said that she did not want to talk about this topic. Thereafter, same page, last line. No, I just want to, these are not my words.
No,
this is what the counselor has reported.
What is this I've asked? She reported that she said so and so. She father tried to play with
They
her.
have just recorded what has happened.
Reported that she did not like meeting the father.
Yes.
When asked if she always felt like that or this was something new, she reported that it was always
so.
She had bad memories of the day she was born.
My lord, she's an 8-year-old child. Now, whatever these are counselor's report, not mine or his report. This is
Saying that sentence itself.
It may not make sense. It may not make sense because nobody can remember.
That all the more shows that something is really not.
I just want to point out.
Yes.
I just want to point out few things which I found relevant to point out. Then the same page, last line, later during another, next page, my lords, later during another activity.
At page number 3.
Yes, continues on page number 3. The child was asked if her father could be involved in the session. She refused, saying she did not want to talk about this. And when asked the reason, she reported that it would be talking about the same topic. When asked if she had told the reason to anyone else, the child said she had told her mother but couldn't remember what was told. The session ended with a play activity. Then session 4 starts. In the session 4 paragraph, about the 7th, 8th line from the bottom, when asked about the last visitation with the father, she reported going there for an hour, seeing a film for 50 minutes that she had already seen, and then coming back. When the child persisted with saying that she did not want to talk about it, the therapist asked her the reason at the time of which she was scared to talk about it. So again, these reasons were asked. Then my lords may go to page 7. Page 7. 7 of 12. The first para about the 15th line. Upon further exploration. My lords found that portion. The sentence starts in the middle of the para. Upon further exploration. She shared feelings of being worried and uncomfortable around her father, though she was unsure of the reasons. The therapist validated her experience and appreciated her willingness to open up, gently encouraging her to think further on these feelings and consider discussing them in future sessions. He also invited her to use strategies such as journaling or speaking with a safe adult or peer whenever she felt distressed. The therapist...
Are you reading the first paragraph of that or the second paragraph?
I'm sorry, I'm reading first para, my lords. In page 7 of 12.
7 of 12.
Yes, sorry. Page 7 of 12. The first para, middle of the para, upon further exploration. There is a sentence which starts somewhere in the middle of the para. Upon further exploration, upon further exploration, she shared feelings of worried, in quotes, and uncomfortable around her father, though she was unsure of the reasons. The therapist validated her experience and appreciated her willingness to open up, gently encouraging her to think further on these feelings and consider discussing them in future sessions. He also invited her to use strategies such as journaling or speaking with a safe adult or peer whenever she felt distressed. Then the same page, second last line, same page. She shared that she felt, my lords found that, uneasy and bad due to events that had taken place in the clubhouse during the 2 visitations to her father, which led to her discomfort around her father. Upon further gentle exploration, the child described that she did not like being forced to play with her father. When asked to elaborate on the nature of play that had caused her discomfort, she expressed that she simply did not enjoy playing with him. The therapist explored whether this feeling was experienced with other individuals, and the child clarified that it was limited to her father. Then, my lords, just kindly leave the next 4-5 lines. Then she changed the version. My lords found that line. Same para. About 10 lines from the top. Then she changed the version.
Page number?
My lords, this is page 8. Page 8. I'll just read from the top. To her father, which led to her discomfort. Upon further gentle exploration, the child described that she did not like being forced to play. My lords have found those lines, right? Forced to play with her father. When asked to elaborate on the nature of play that caused her discomfort, she expressed that she simply did not enjoy playing with him. The therapist explored whether this feeling was experienced with other individuals, and the child clarified that it was limited to her father. Now, my lords, kindly 3-4 lines, my lords may skip. In fact, that day I was born, that is what the therapist explores. Then she changed the version. My lords found that line. Don't like my father for a long time that I remember. The exploration continued regarding the nature of the discomfort, and the child described an incident at the clubhouse where her father picked her up and held her upside down, and she demonstrated it in the session using a doll. She also expressed how her father had touched her on her bottom. Her feelings were acknowledged. At this, the child inquired whether she would have to meet her father that day. When asked what she wanted, she expressed that she did not wish to meet him, explaining that his presence made her feel uncomfortable. At this point, the therapist explained the presence of a court-ordered visitation arrangement and emphasized that court orders are binding and apply to everyone. The child mentioned that she had been told it was her choice whether to meet her father. The therapist affirmed that while the court's order is there, the child's preferences are also important and would be communicated. He acknowledged the challenges of speaking about sensitive topics and encouraged her to take a break. Then, my lords, kindly skip 2-3 lines. The child again verbalized that line. The child again verbalized about not meeting her father, and the therapist again affirmed that her choice would be respected and communicated. Then the child asked about what would happen after the session. The therapist explained that he would be meeting with her parents to provide feedback. The child remained silent, and the therapist gently reiterated that confidentiality would be maintained and that the ultimate aim of the sessions was to support her. He then explored whether she had ever shared her feelings of discomfort with her father, to which the child responded that she had spoken to her mother about them and maybe to the court, but not directly to her father. When asked whether she had expressed a discomfort during play with her father, she responded negatively. The therapist then inquired about the frequency of the events the child described, and she responded that the incident involved being turned upside down occurred only once, and the bad touch may have happened twice. The therapist gently offered that at times parents may engage in physical or playful interactions with their children as a means of expressing affection, which may not always carry a bad intent. The child acknowledged this possibility but clarified that the experience had made her feel uncomfortable. The therapist acknowledged her feelings and explored what made her think that her father's touch had been bad intent. The child replied, "I don't know." When asked whether it was more of a feeling or her belief, she affirmed that it was a feeling. It was also inquired whether an incident like this had happened at other times, to which the child responded that it had happened only during the 2 clubhouse visitations. The conversation further explored the context of the incident, including whether her mother had been present during the visitation. The child expressed that her mother was sitting at a distance within the clubhouse during the visitation. It was also clarified, continues on next page, my lords, that the visitations happened in an open space where many other club members were present in the area, in the same area. The therapist also gently inquired whether the child had experienced similar discomfort with other individuals, including strangers, to which she responded negatively. At this time, the child expressed a desire to end the session. The session was concluded with a brief breathing exercise and the use of a teddy bear as a self-soothing strategy. The therapist provided a rationale for that exercise, explaining that sharing personal experience may be emotionally difficult and encouraged the child to hug the teddy bear. Now, my lords, may see page 10. Page 10. About 4th or 5th line from the top. To explore the origins, that line. To explore the origins of her discomfort, the therapist inquired about when her strong feelings towards her father had begun and whether they were linked specifically to the clubhouse visitation. When the child responded with silence, confidentiality was reiterated. The child then shared that she felt uncomfortable when her father would force her to engage in certain behaviors like eating food that she did not want or being asked to give gifts to others. She explained that this caused her distress. The therapist validated her distress and encouraged her to guess possible reasons behind her father's actions. The child expressed that maybe her father wanted her to eat, which the therapist acknowledged and appreciated as a thoughtful insight. When asked whether anyone had advised her to feel this way toward her father, she stated that no one had and admitted that these were her feelings. The conversation then shifted to her sleep routine. Then, my lords, may just see page 12, the last. Page 12. These were all the sessions. The last page 12, the title is Sessions on Preparation for Visitation. The counselors had, the doctors had sessions with the child about visitation. And this is their record. The third para, session 2. Session 2 on 26/5, the child was seen separately for a session and discussed her interests, routines, well-being. She discussed her interests in summer vacations and spontaneously said she could not take a long vacation since she has come to Nimhans for sessions and she wished that she could stop coming to Nimhans. On gently probing about the reasons, she reported that she could do other useful things in that time, and on asking whether she finds Nimhans visits to be useful, she said she doesn't know, but she doesn't like coming to Nimhans and that the sessions are okay for her, but she does not like visitations. And then that same para, about 4th or 5th line from the bottom, on discussing preparedness regarding visitation and support needed from Nimhan's team, she reported that she does not want to have visitations with father and Nimhan's team could help by communicating the same to court. She refused to discuss further about the visitation. Then session 3, the third line, child reported that she is not willing for preparation towards visitation and no support will be helpful for her and she refused to discuss further. Parents were seen together. Discussion with parents focused on reaching a consensus regarding visitation. Mother was of the opinion that child is afraid and not willing of visitation and should not be forced, and that NIMHANS can act as a third party for visitations, and raised concerns regarding safety of the child during visitations.
What is this girl's safety raised by mother? What does it mean?
No, the supervised visitation, because the girl reported that on 2 days in the clubhouse, which was also reported to my lords. Ultimately,
in spite of the fact that the mother also understands, girl is telling something which has not at all happened, but still keep on saying about her security concerns. Is it not that she's validating what the daughter is saying?
No, may I just respond? May I just respond? What I read out were the session notes made by the NIMHANS.
No, that's what they have recorded.
They have recorded the session notes. These are all recorded by them.
No, the mother has.
Yes, she has said it, and I'll give my lords the reasons why the mother has said it. The only reason the mother has said it is because, as reported in the earlier session, the child herself has said that on 2 visitations in the clubhouse, she felt uncomfortable with what happened.
She is feeling uncomfortable for everything without any basis. That cannot be the basis.
My lords, I don't want to read in and make any further judgments. The 2 things she said is that one is the father put her upside down, and then on one occasion he touched her bottom, which she said made her feel uncomfortable. Now, whether that was done with a good intent or a bad intent, it is for no one to assume. Nobody can know, because the father and the child were there together. But the child has reported that it made me feel uncomfortable. So the visitation sessions were held separately with the child. In fact, the cover letter, what I want to state, my lords, is that ultimately, my lords, even the supervised visitation that my lords directed, we were carrying out.
She said that
we were carrying out.
No. There also she said that father was touching her before everybody.
In fact, the video, my lords, the video that I showed my lords, and based on which my lords made that record, he's forcing her, touching her, my lords. In fact,
before going into all that,
yes,
why the mother is wasting her time, course time, child's time by doing all this? Why not 3 weeks of admission won't work out?
My lords, the child is going to school. She has exams.
What school? Overall development of the child is what is important.
No, I can ask the mothers here.
No, we will pass an order. No, I'll not waste further time on this.
I just want to make one. May I just make one submission?
Yes.
My lords, may just.
I've already given a long hearing.
Yes, we are fully.
This is not required now.
My lords,
we can't waste our time.
My lords, may I just look at just for a moment the cover letter? Just for a moment. Just the cover letter. In the cover letter of 13(6), what they state, in fact, that regarding visitation, we have tried to prepare the parents for a consensus, but child appears reluctant. And then, in fact, they state that as at one point, they have stated that we were unable to see the interact with the child without the mother or father. In fact, every session has been held by NIMHANS as per their requirements. Child has gone. Whether parents are asked to come or not, they are waiting outside. Only if they are asked to come, they go in. So whatever the NIMHANS wanted, if they want the child to interact with the father is there, they can easily call him. Mother has not stopped that.
That's precisely what it is.
Whatever they want to explore.
What the doctors are repeatedly saying, even the director NIMHANS also said, with these kind of disputes between the parents, no, they do a counseling for an hour. She go home. She's there for the next 23 hours with the mother.
Yes.
That's not possible. That's what precisely he said. For her, for in this case only, I called him because she's looking at her age. And
I'm just wondering aloud as a parent as well. I'm just wondering aloud.
Let them.
What happens to the child's school if she is put inpatient? May I just take instructions?
Your Lordship, at the age of 8, I don't think she's going to miss her doctorate.
Yes, because the mother is more concerned about her marks than her.
In fact, the mother just mentioned to me that based on my lord's earlier orders for 1 week inpatient, she was.
What all she did that time, I also know.
1 week.
She made her to travel 24 kilometers during the summer and all resulted in it.
She was
All of
Remember,
this is
I
covered
remember
in
all
the
those
Supreme Court
orders.
judgment,
Now-
Your
now
Lordship.
this is
Even
not,
about studies,
this is
Supreme
not
Court
going to
judgment
work
has
out.
covered it.
And
I'm sorry. Now,
the daughter's psychological condition is, it is at a very alarming stage. It doesn't, with all these therapy sessions, nothing is going to happen. We have to leave it to the doctors. Court exercising the parent patriarch jurisdiction will
we are
take into.
ultimately, may I just make one submission?
Yes, yes.
Ultimately, we are in my Lord's hands.
Yes.
My only concern is, she's an 8-year-old child.
Yes.
To put her into an inpatient situation. And I would say, even for any parent, father or mother, ultimately that should be the concern. We are only concerned about a 8-year-old girl
That is
being
exactly,
put inpatient.
Mrs.
I feel, my lords, with great respect, that is a very, very severe suggestion that even
I think that is already, if you look at the other judgment, the Supreme Court has also considered this,
Yes.
what it is.
Correct.
when, in fact, I'm just curious, I may not be fully aware of the other judgment, although I'm aware of the case, whether in the other judgment also fully inpatient, my lords, have ordered.
That's what ordered.
And whether
What has happened, but only difference in that is, now by the other day, yesterday when the matter came up,
yes,
when the NBWs were issued and the available warrants were issued against the mother, they have come and they have filed a joint memo, all they've compromising everything, divorce, visitation, everything is settled. And that's how it ended up yesterday.
in fact, the Supreme Court order, if I can just read out,
Your Lordship,
and if,
please read.
none of
I
this
can
would be
just read
necessary.
out-
I understand
No, no.
her concern alone.
May I
in
That's
just
what
read
the
out?
decision of
But
the
they
court.
have
The
brought
conflict
into
is
this
only that.
situation. Had the mother not done all of this, the child would not be in this situation.
Pause.
So therefore, it is her own doing that the child would have to go in
may I
there for
just
so
read
long.
Para 16.
And
Just for my
all of
understanding.
what learned senior
No, let
counsel
her
has stated
read-
is
let her
covered in
read
the
that,
judgment.
paragraph.
I'll just read out, because ultimately, let us, we are only doing all this effort in the child's interest, nothing else.
That's what everybody is
We are
interested
only
in.
interested in that. Para 16, if I can just read
Please
out,
read.
my lord.
Of what?
We have already directed that the child would be taken by the district child protection officer along with the mother to NIMHANS on so and so date at 11:30. We clarify
independent.
that after the admission of the child for her independent evaluation, the doctors in attendance would take a decision regarding stay of the mother with the child or her visitation during the period.
Supreme Court has gone
No, of course,
a step further.
we are bound by what the Supreme Court is, or her visitation during the course.
No,
of
no,
the-
we are not. There's a twist here. She's now trying to say, in this we are bound by the Supreme Court. Therefore, trying to restrict your lordship to not pass any other order to it.
I'm not.
We can't read everything in.
No, let
I
her
am not
come back and
putting
understand
any,
what is,
I'm
what
only
is that
trying
she
to
wants to
understand
say.
how the Supreme
Yes,
Court has
please,
evaluated,
please
has
read, please
directed.
read.
The doctors in attendance would take a decision regarding stay of the mother with the child and or her visitation during the course of evaluation of the child at NIMHANS. Likewise, the doctors in attendance would also take a decision regarding visitation of the father on such date, time and frequency during the period of evaluation of the child at NIMHANS. Such a decision would also be taken regarding the visit of the district child protection officer on completion of the evaluation exercise. NIMHANS shall furnish a report to the Registrar Judicial of the High Court of Karnataka in a sealed cover. Post-evaluation, NIMHANS shall permit continuation of the custody of the child with the mother as previously ordered, with visitation facility for the father depending on their evaluation. Now, I'm only trying to clarify whether any timeline for this, if my lords are suggesting inpatient.
3 weeks.
Sorry,
3 weeks.
whether 3 weeks was, I mean, if my
Yes,
lords are saying, I have no
the
reason to
doctors,
doubt.
whatever the doctor suggested, that has to go on. Now, at least on the last occasion, this court has passed an order that mother could be with the daughter. But the Honorable Apex Court said whether the mother's presence is required or the father's presence, that the doctors will take a call.
Doctors will take the call, but ultimately they said the doctors should do the evaluation as per their
Now,
recommendation.
here, there is no treatment going on. They're only
Correct.
trying to
an
evaluate what is the
evaluation.
difficulty of the child.
It is an
No,
evaluation.
that is in the long run is going to affect the
Receive
child. If
35
the child
rupees on
grows up
Google
with
Pay
this
for
feeling that
business.
father has done something to her, does the mother think that it is all right? And with 1 year,
Ultimately-
in a matter of 1 year, she couldn't achieve anything. That's what court has given her the enough chance to, whatever possibilities she can.
My lords are right, but ultimately the only submission, my lords, is that the concern, I just want to, just for a brief moment, the difference in this case and the other case. is that in the other case, which led to
Other
this,
case is much better than this. Because
I would, with great respect,
no,
disagree
no,
to an
because,
extent.
no.
I would
In
disagree
the
with
other
great
case,
respect.
the child is not attributing all these kind of bad touch, good touch to the father.
Yes,
She
there
just
was-
says, I don't
I
want
don't
to
want
see
to
him.
be. But in
And
the
this
other
case, she says something
no,
which
but
is,
in
nobody
the,
can
to
believe
that,
it.
to that, in the other case, the reason why I state it's different is because there were orders for visitation passed by the court, and they were repeatedly flouted by the mother, and therefore the ultimately contempt and all
We
these
are
other-
on- we are on
we have
the-
not ever, the mother at any
No, not
point
on
of
that.
time
You can't
have-
compare it that way. You
No,
have to
only to
compare
that
it on
extent.
the psychology of the girl and what is the mental
My
state.
only comparison is that whenever visitation orders have been passed, the mother has never tried to flout it or disobey
No,
it.
let's not put the
Yes.
girl into this kind of tension forever.
My
Let
only
her, first of all,
concern
let her
is
get out of,
if-
let her get out of all this
if the
psychological
inpatient-
issues.
The only concern, my lords, is inpatient for a young girl of 8 years. She's a school-going kid, and to be in a hospital environment,
Not able to
I think even
understand.
we should be concerned about that. That putting her in a hospital
Do you think
environment.
that do you think that the doctors are not aware of it, or doctors are not concerned about? If they are not concerned about her health, why are they like they want patients to be admitted in the hospital?
My lords may just see just the reason my discomfort is there. I read out what, according to me, were the relevant portions of each session findings.
Yes.
After the session findings, in the session findings, the girl, whether it is true or false, it is only for the girl and father to know what happened. Girl has said 2 incidents happened in the clubhouse, which made her feel uncomfortable. Now, the NIMHANS covering letter, the covering letter says, based on the evaluation, child appears to have misinterpreted about abuse, and it is clear that it has not happened. Child has expressed negative views. Now, I'm only asking, the evaluation, the session notings are there, where the child says XYZ incident happened. Now, the finding given by the team to say it is now clear that it has never happened.
No, no.
My lords, how can any?
Let's not go into that. Let's not attribute anything to the doctors, anything.
No,
to
no,
them.
it is not attributed.
Ultimately, if they are not there, the girl will be nowhere.
No, no.
So let's
no,
not
it is
attribute
being
anything to them.
attributed,
Your
but
Lordship,
the
one
reason I'm-
sentence
the
which
reason
the
I'm
learned
saying-
senior counsel read
reason
itself
I'm-
states it.
No,
Your Lordship,
no,
2 sessions.
No, what is the reason for this court to take that step of taking the dog? I mean, admitting her in enhance. That order is a detailed order.
Yes, yes.
Wherein before this court, without even the mother has accepted
In fact, my lords
Taking-
interacted with the child.
with the child,
My lordship.
and what she was saying, the videograph of the entire session was there. Was sitting between, even the advocates were there. She is also there.
No,
And
no,
she
I've
also
seen the
accepted
video.
that.
I've seen the
Nothing,
video.
she is under some kind of we don't know what is it, because we are not competent to say what is her state of mind.
In fact,
So
I've
let's give
seen
it
the video. I have also seen the video, because I said, let me see to know exactly what has happened. And the mother was not there, and there were other 1 or 2 videos where the father is holding the child from the back. At least that is the video I saw. That the child is on the lap or
No,
something.
which one you saw?
I
Like
have
all of them sat down, and she was doing some activity,
Not
sitting
that,
on the floor.
no.
That's the
No,
one.
no,
That
no,
is the
that-
one when
no,
the
not
court
that
has
video.
interacted with them.
Not that
Yes.
video. There is another video.
No, that's the video when the girl came and expressed to the court that father was doing something which is not right. Then all of them were there in their presence. She said, then the court could understand that something is not right. That's why all this. Now we have wasted already 1
Now,
year's
my
time.
only submission is, if could my lords reconsider inpatient, because
Not
that is
inpatient, nothing is going to happen. We will not. Now the doctors will say they will not do anything. We can't ask the doctors to do the treatment as per how we want
Can
and
I
how
just
the mother
take? Can I
wants.
just take?
Please ask her.
Your Lordship, the portions that have been read are only the portions that it was convenient. There are so many other portions, Your Lordship, which are very positive.
I have
The
seen that.
other thing also is, if they have any difficulty with NIMHANS directly of giving a clean chit, then it also records, they ask the child, and the child has responded, did this happen any other time? No, it happened only during the clubhouse, which means all through her life it's never happened, and it seems to have happened only at that particular
I
time.
only want to make
Whatever-
one.
That is the words of the child itself.
Whatever the girl says, let's not take into consideration, because as of now, we know that her state of mind is
Yes.
not correct.
Yes.
That has to be evaluated by the
Absolutely.
doctors, and they should give the report. Till such time, let us not go into any of these
Please,
issues.
please.
That's number one.
Yes.
Number two, as observed by the Honorable Apex Court in the other judgment, this court is not going to pass any orders with regard to the visitation. Whether the mother's presence is required, father's presence is required, how it has to go forward, that they will decide.
Please, please.
Then may I just make my ultimately my lords may pass orders, but my instructions are that inpatient, which was done last time by the orders of my lords for a week, was extremely difficult for the child. As per the mother, she fell sick. She was physically
That I'll record.
sick.
I will record
Yes.
all that
And
reasons why
therefore-
she has fell sick.
And she has fell sick, and that inpatient was not at all in her interest as per the mother's view. Thereafter, my lords agreed for outpatient. Outpatient
It is
is what
going on for 1 year
where-
without
it
any
has been-
change.
Now, clearly, during the outpatient in evaluations and interactions, the girl has said that she is not feeling comfortable, and therefore, my lords, for inpatient, certainly we are not agreeable, but let this be recorded, my lords, that
Yes.
the inpatient is not something
Yes.
that the mother is agreeable,
Yes,
as it will affect the child. She has exams now. She has 1 month of exams in school, which she has to finish her academic year. And in fact, even this has gone on for a year. In fact, all this is weighing on the child.
No, mother is not bothered what's happening with her.
No, mother is
But
certainly
mother is
bothered
only
about the
bothered
child.
about- Mother is only bothered about, if anybody. who is
certainly
very
the
good-
mother is
No,
bothered
no,
about the
who
child.
is very good at studies, that's the only thing that's required.
Not studies, my lords. It is
Then-
not whether she gets
If
a
she-
A
that
grade or B
shows
grade.
There are no bona fides on the part of the mother to see
In
that
fact,
the,
mother
the
has-
overall development of the child is
In fact,
taken care of.
the court has recorded that even when Nimhans was going on, the mother was taking her Manipal. If
Why
the
should
mother,
she? No,
because
what
at
does it
that
do?
time,
No,
the-
she doesn't have any trust on an institution which is
in fact,
considered to
even
be a.
before Nimhans, I'm only making a submission that the
And
law
what is
court
the
has
outcome
recorded.
of it? What is the outcome of it? That's what we are
Because
bothered
outcome
about.
takes time. Outcome does not happen with great respect.
1 year,
Outcome in
1
the-
year also, but what is the difference? As it is, as it was before
This
the court.
is
even
6
till now
weeks. It
it's
is not 1 year. It is 6 weeks.
No.
It is, my lord.
The last order is on 10/7/2024.
And even
At
before
that
that,
time,
it had
there was no
started.
counseling. With respect, I just want to clarify. These sessions, in fact, the 10/7 order.
When is the order passed by the court?
My lord, this order
On
is,
12/3/2025.
on 4/2 from February. The
On
counseling for Nimhans was
12/3/2025,
on only
an
from,
order is passed by
4/2.
this court.
It is not from 1 year, with great respect.
As per the order dated 4/2/2025 passed by this court, a report is placed before this court by the director Nimhans, and basing on that, this court has passed an order on 12/3/2025. Extract the entire order. Basing on the said order passed by the court, a report is placed before this court. The report dated dated 13/6/2025. This covering letter, entire letter, extract and paste it. Today when the matter came up, both the senior counsel appearing on behalf of the mother and the father have advanced their arguments. Then senior counsel appearing on behalf of the father submits that the report of the Nimhans is very clear that unless and until she is admitted as inpatient, it would be difficult for the doctors to evaluate the girl. She had relied on a judgment of the apex court in case of Ms. Amrita Sinha versus Sweta Sahai, arising out of special leave petition C number 17006 of 2025, dated June 25th, 2025, wherein in a similar facts and circumstances, the Honorable Apex Court as affirmed the order passed by this court. And para 16 of the order, the court had observed as follows. Extract para number 16, 16, 17, and 18. Basing on this judgment, it is submitted that this is a fit case where the girl has to be admitted as inpatient. Then the senior counsel also points out that this court had passed several orders in this matter, starting from starting from 5/6/2024, this court had submitted that right from 5/6/2024, several orders were passed by this court. And in fact, earlier, by order dated 10/7/2024, had directed the girl to be admitted in the hospital. Thereafter, mother has come before this court and expressed that the girl is not comfortable. And thereafter, on several occasions, this court has also granted visitation. And it is stated that the mother is taking the girl to NIMHANS. Senior counsel submits that there is no change in the attitude of the girl towards the father, and that has been recorded by the NIMHANS in the report that is placed before the court. It is submitted that unless and until the girl is admitted in the hospital, it would be difficult for the it is difficult for evaluation. And senior counsel appearing for the mother submits that it is not acceptable for the mother, but the the girl can be treated as outpatient. Inpatient, the facilities at NIMHANS are not good. And earlier also, when the girl was admitted, she had to face a lot of difficulties. And considering her
fell sick also, my lords, may record. She fell
sick. And because considering all that, thereafter, court had directed the NIMHANS to evaluate the child. It is submitted that the girl is going to school. If she has to be admitted, she is having exams, and it would have an impact on her academics. Even on that count also, admitting the girl in NIMHANS is not appropriate in the interest of the child. Further, according to the senior counsel, the counseling sessions, like how this is going on from the last 6 weeks, should go on. And basing on that, basing on the further report from the NIMHANS, the court can pass orders. The senior counsel has pointed out certain paragraphs from the report of the NIMHANS. In this, I have pointed out, I have underlined all that you extract. Entire report, wherever I have underlined that I extract. It is submitted that the girl is showing utmost reluctance to meet the father. And in these circumstances, the further sessions with the NIMHANS will be in the interest of the child, but not admitting the child as an inpatient, considering her age and her well-being. Anything else?
Also to say that whenever the orders for visitations were passed by the court, we have
It
complied.
is submitted that the
We have
mother
never
is
tried
not
to-
with the order,
They have not been
with the
complied.
order of visitation. And in this case, the
Supervised visitation that my lord, the supervised visitation with third party
and,
supervision that my lords had.
And in this case, as the senior counsel was relying on the judgment of the apex court, in the said case, there was constant violation from the mother in complying with the order of visitation, and the same thing is not there in this case, and the mother is always ready and willing to honor the orders passed by this court. Hence, the court may not pass orders admitting the child in an enhanced. Hurdle and the senior counsel on either side, where is submitted not recorded. In this case, when the matter initially came up before this court, where the father is seeking the visitation.
Apologies, my lords, apologies. May I just make one more submission? In the cover letter, what Nimhan says, given the challenges faced in the outpatient-based evaluation, and there has been no chance to observe the child in the absence of the mother with her father.
Mother, comma with her father. The comma is critical.
Mother, comma with her father.
Your lordship, I have been very patient all along. Everything that they said is recorded. I have not even insisted on what are the positive things. Here, I will not let them misinterpret. It says there has been no chance to observe the child in the absence of the mother, comma, with the father. Meaning with the father we could not observe. With the mother they have observed.
The same
No.
I'm only saying the Nimhans had the full freedom to have the sessions in any combination that they wanted. Whether they want the child alone, whether they want the child with
They're
the
not
father.
referring to that
Nobody
1 hour.
has
They're not referring to that 1 hour. Or the child, even in that time also, she says that after a time, I do not want, I leave from the place.
If they wanted, in fact, to observe the child and the father, we were at their instructions.
No.
They can call anybody however they want to
The
observe.
father has fought for the visitation.
Yes.
When it is brought to the notice of the court that the mother is
We have never,
along with the child in Calcutta. And it is submitted that as per the orders passed by the court, the visitation rights will continue till vacation after the child comes back to Bangalore. This order was passed on 23/4/2024. Then on that day, it was brought to the notice that whenever there is visitation with the father, the girl is undergoing tremendous mental stress. Then on 5/6/2024, this court has passed the following order. Extract that order. Then on 12/6/2024, this court has, after the visitation went on and after interacting with the child, this court has passed order on 12/6/2024. Extract that order also. Then on 9/7/2024, the doctors at Nimhans have placed a report before this court, wherein they have found that the child required 6 weeks of admission in the hospital as an inpatient. Then the matter was adjourned to 10/7/2024. Then on 10/7/2024, a detailed order was passed wherein the girl was directed to be admitted in the hospital. Order dated 10/7/2024 also you extract. Then on 18/7/2024, that the mother has moved a memo stating that her exams are starting from 22/7/2024 to 26/7/2024. As such, the girl can be admitted after Friday, that is on 26/7/2024. But however, And this court has directed that the girl shall be admitted in Nimhans on 22/7/2024. Then on 24/7/2024, it is submitted that as there was no special room, the girl was not admitted. When the matter came up on 1/8/2024, it is stated that now the mother has come up with an application for modification of the order, stating that the washroom, the room in the hospital are not clean and not well maintained. As such, the girl has developed urinary tract infection and she is admitted in the hospital. And hence a petition is filed seeking modification of the order dated 10/7/2024 and permitting her to stay at her residence and visit Nimhans for psychological evaluation as and when required. Then this court has observed that when they say that the hospital conditions are not hygienic, they should have brought this to the notice of the hospital authorities. And it is a responsibility of the hospital authority to see that the child stays in a hygienic condition in the hospital. The affidavit that is filed before the court do not disclose that such an effort is made. Every day, the mother was taking the girl to the school. The distance between the school and the hospital is about 25 kilometers. And from the last 3 days, the girl is made to travel that distance. The court has also observed that the mother is not much concerned whether that contributed to the dehydration and the stress of the girl. But according to her, only the hospital conditions have contributed to this.
Your Lordship, also that she unilaterally pulled her out of the hospital and went and took her to Manipal and put her in. So we don't know whether there was any such incident at all also.
No, no.
She
In
just
fact,
pulled
the
her out
school
and she
thing,
decided to go and get some medical
doctors
records.
This court has
themselves
also
said
observed that
to take
this
the
is the
child
high
to
time.
school.
The parents have to realize this. It's a responsibility of the hospital authorities to see that the patients stay in a hygienic condition. And if the conditions of the hospital are not hygienic, as complained by the mother, it is the responsibility of the hospital authorities and they should take care of them. And this court has passed an order that till the next 6 weeks, whatever the doctors say, the parents shall follow and they should not come to the court until the 6 weeks period is completed, until the report is given by the NIMHANS, and both the parties were directed to cooperate with the hospital authorities. Then on 30/8/2024, an order is passed for this court, and this court had recorded the report placed before this court by the NIMHANS, stating that for various reasons they could not give the treatment to the child, and they have also stated that for the purpose of school, the girl is leaving at 6:30 a.m. and coming back in the evening. Earlier, the school authorities have also given permission for a period of 6 weeks for the child. Though the court had passed an order long back by filing one application or the other, and on one pretext or the other, by the mother, so far treatment could not be given, and they could not analyze the state of mind of the girl. Then finally, the court had passed an order directing the mother to admit the child on 31/8/2024 at Nimhams, and the mother shall adhere to the advice given by the doctors. And she cannot take her independent decision and cannot take the child wherever and whenever she wants. The doctor shall treat the child, and the interest of the child should be the paramount consideration and not the request of the mother. Then again, this court has passed a direction to the NIMHANS to evaluate the child. Then again on 25/9/2024, this court has observed that in spite of an order passed for this court, in spite of several orders passed for this court, on one reason or the other, the mother has not joined the child in NIMHANS. Then when the court has also observed that as a mother is not complying with the orders of the court, this is a clear case where a suo motu contempt proceedings have to be initiated, and directed the matter to be listed on 1/10/2024 and on that day, appropriate orders will be passed by the court. On 1/10/2024, when the matter came up, it is submitted by the mother that there is a lot of reluctance from the daughter, and in fact, she has been taking her for counseling. Now she has improved emotionally and otherwise. There is a lot of change in her. Concerning the said submission, though the mother has blatantly violated the orders of the court, considering the welfare of the child, the court made an interim arrangement from 6/10/2024 to 30/10/2024, where this court has permitted the father to exercise a visitation for 2 hours between 6 p.m. and 8 p.m. at Prestige Shantiniketan Apartments cafeteria, and the mother was directed to cooperate with the visitation. In this order, dated 4/11/2024, this court has recorded what has transpired on the earlier occasions and about that the girl is not feeling well, that she's suffering with urinary tract infection. As such, she could not join the girl in the hospital. This court has observed that when that is the case, mother has not even bothered to come up with an application before the court. And once the father moves the application for visitation, now it is stated before the court that the daughter is not interested. Daughter is showing resistance. And there, the mother tells the court about the therapy sessions. Then again, another order was passed. Then at paragraph 7 of the said order, this court has observed that what has been looking at what has transpired in this case right from April 2024, the court feels that there is a lot of reluctance from the mother to admit the daughter in the hospital. It is stated that the girl is not interested. This court observed that the mental condition of the girl appears that she requires treatment. The mother cannot submit before the court that the girl is reluctant, and the court exercising the parent patriot jurisdiction has to take care of the welfare of the children than the concerns of the parents. Then the court also observed that the court has personally interacted with the doctor to find out whether the inpatient treatment is required or not. Then, considering the concerns of the mother, this court passed an order directing passed an order that by the next date of hearing, the father shall come up with the details of hospital and the facilities that are available at any other hospital for the inpatient treatment of the daughter, and also granted the visitation. Then it is submitted that the visitation went all well compared to the